some reading and research in media related legislations and right to information, I think I was given this opportunity and I deem it extremely pleasant to be on the dais along with the luminaries here. It's really a great thing that you are talking about governance, good governance and oxygen of information. Information is really oxygen, and if there is no information, there is no knowledge, and if there is no knowledge, there is no wisdom. There is nothing that you can gain without thinking power, and thinking power cannot get activated without information. I hope you all know that you have liberty of thought. మీ అందరికీ ఆలోచించే స్వాతంత్ర్యం ఉందని తెలుసు అనుకుంటాను. ఆలోచించే స్వాతంత్ర్యం ఒకటే, అవధులు లేని స్వాతంత్ర్యం, పరిమితులు లేని స్వాతంత్ర్యం. There are no limitations to liberty of thought. You can think of anything. ఎవరు అడిగారు, can I think of anything, sir? Yeah, my answer is yes. Can I think of killing of a person like Manmohan Singh? Answer is yes. Answer is yes. Not that he is bad. I'm only talking about thinking power. Not that that person should be killed. Not that you must aim it at that. But your thinking power has no limitation. You can think of anything. But then question is, what do you think and what do you say? Question of thinking, liberty of thinking is followed by liberty of expression, with which we are all concerned. We give information, take information. We communicate information. We talk about public relations, and public relations cannot happen without information. What is that information you can give, or what is the relationship that you can build without giving any information? ఏం చెప్పాలో తెలియకుండా ఏం చెప్పినా అర్థం కాకుండా ఉండేందుకు ప్రయత్నిస్తూ ఉంటే ప్రజా సంబంధాలు పెరుగుతాయా, పాలనా సంబంధాలు పెరుగుతాయా? Whether your governance get established, your governance get qualified and quality of governance be improved without communication of information? This is the major question that we are supposed to think about. Today Afzal Guru was hanged. His clemency petition was rejected by the president. The president rejected clemency petition based on the recommendation given by Home Minister. And nobody knows when Home Minister rejected clemency, recommended President of India to reject the clemency. Nobody knows what are the grounds on which he recommended. Nobody knows why President has exercised his discretion based on the advice of Home Minister. Nobody knows when it happened. But by the time you got up at early 8 o'clock, or by the time you switched on the televisions, you came to know that Afzal Guru is hanged. Not that Afzal Guru should not be hanged. Not that Ajmal Kasab should not be hanged. Not that... Any point? Do you want me to continue? Happened today, and that's why I'm telling. This is indication that we do not know. This is the indication we are supposed to know. We are I mean not you and me. We mean entire nation, entire world is supposed to know. My question is, we are discussing on oxygen of information in governance related subject matter. I think this is the most contextual example with which I can start my discussion. We need to know, as a citizen, I need to know who has authority to grant mercy. Because I am also a constitutional student, I would like to say, according to Article 72, it is President of India who is supposed to exercise his personal discretion to give mercy or not. I am absolutely not supporting, please don't misunderstand me about Afzal Guru. I am talking about governance mechanisms. I am talking about information systems. I am talking about transparency issues involved in any major decision by the government. Decision making process of the government is supposed to be transparent, and that's what right to information talks about. That's what right to information is about. So when is that you have decided against the clemency? Why is that you have decided against the clemency? I have a right to know. This is what is the Right to Information Act that gives you. నాకు ఈ దేశంలో తీసుకుంటున్న ప్రధానమైన నిర్ణయాలకు వెనుక కారణాలు తెలుసుకునే హక్కు ఉంది. ఆ హక్కునే సమాచార హక్కు చెప్తున్నారు. ఐఎమ్ ట్రాన్స్లేటింగ్, I read your slip. That's why I'm translating it not into Hindi but into English. I think this is obstructing me. It's an abstraction to information. So the problem is, why are we continuing with the culture of secrecy? That is the problem. India's traditional history is based on discussions and debate. We believe in questions and answers. Kathopanishad, Prashnopanishad. These are all questions. Kenopanishad. These are all questions and answers. The people believed in transforming transmitting knowledge through discussions. Do you know what is democracy? Democracy is simply defined as governance by discussion. Governance by discussion. You may wonder to know whether anybody can govern with the discussion. Where unending discussions, hours together, and somebody jokingly said, చట్టసభలో డిస్కషన్ చేస్తే తప్పలేదు, చేయట్లేదని నా బాధ. ఇప్పుడు చట్టసభలో ఇఫ్ దే ఆర్ డిస్కసింగ్ ఇన్ లెజిస్లేటివ్ హౌసెస్, థ్యాంక్స్, దే ఆర్ డూయింగ్ ది రైట్ థింగ్. బట్ ఇఫ్ దే ఆర్ ఫైటింగ్, ఇఫ్ దే ఆర్ హిట్టింగ్ ఈచ్ అదర్, ఇఫ్ దే ఆర్ అబ్యూజింగ్, వాట్ టు డూ? I raised a very interesting question recently. Whether the unparliamentary expressions are limitations on freedom of speech and expression is the question. I posed it to my media law students in my class. They said, yes, why not, sir? How can you use unparliamentary expressions? You are not supposed to talk about unparliamentary expressions. Then I asked him, Indian Parliament has published a book called Unparliamentary Expressions. Entire book contains about unparliamentary expressions only. Can they publish? Can they circulate that book? Can they give it to you? Can you read it? Answer is yes. Answer is yes. Without knowing what is unparliamentary expression, how do you stop using it? That means what? You have to use it for once at least. There is one interesting episode in legal decisions with regard to liability. Animals are divided into two classes: wild animals and mild animals. Very simple. You don't know to which class we belong to. Man is a social animal. It is Aristotle's definition. Man is a social animal. Somebody said underline animal. Underline animal. So wild and mild. And a person is expected to keep a pet animal with him, provided it is mild. If you are having a mild animal as your pet animal, there is no liability, because it doesn't cause any harm to anybody. There is no liability. If you keep a lion as a pet in your house, you are supposed to take extra care, and whatever is the consequence of that lion's or tiger's interaction with our relationship with the onlookers or guests, you are supposed to be liable. That is a general liability. It is called occupier's liability. Then the dilemma was where to place dog. Is it a wild animal or a mild animal? మనం కుక్కలు పెంచేవాళ్ళు జాగ్రత్త, ఏమన్నదండి మీరేం రందిపడకండి, ఏమన్నది, అది ఎందుకు భయపడుతున్నారు అంటారు. ఏమన్నదని నాకు తెలుసు, మీకు తెలుసు కదా, దానికి తెలుసా అన్నాడు ఒక ఆయన. ఆ కుక్కకు తెలుసా ఏమన్నదని? So who knows whether does it know that it should not bite? Don't you know barking dogs do not bite? I know, sir, but does it know whether dog knows that it should not bite me? అని అడిగాడు. అల్లాడి కృష్ణస్వామి అయ్యతో ఉంది జోక్, ఎక్కడ పోతాయని అట్లా అన్నాడు. అయితే మరి ఆ కుక్కకు కరిచేదాకా, కుక్క వైల్డ్ ఎనిమలా మైల్డ్ ఎనిమలా కరిచేదాకా తెలియదట. ఒకసారి కరిచిన తర్వాత అది వైల్డ్ ఎనిమల్ కింద కేటగరైజ్ చేయాలట, కరవక ముందు మైల్డ్ ఎనిమల్ కింద కేటగరైజ్ చేయాలి. దెన్ వాట్ డస్ ఇట్ మీన్? దీని నుంచి ఒక సూత్రం వచ్చింది. ఏమిటా సూత్రం అంటే, ఎవ్రీ డాగ్ హ్యాస్ ఇట్స్ ఫస్ట్ ఫ్రీ బైట్. అంటే ఒక కుక్క ఒకసారి కాటేయచ్చు, కాటేస్తే నువ్వు యు ఆర్ నాట్ లయబుల్, బట్ ఇఫ్ ఇట్ బైట్ సెకండ్ టైం యూ మస్ట్ పే. So what is the basis of this difference of liability? Information. Information as to what? As to propensity of the dog, as to the cruel attitude of dog. So once I know that my dog is prone to bite you, and if I still keep it and allow it to bite you, I must be responsible for the consequence of the dog's biting. Information is a very, very important characteristic in deciding liability అని చెప్పడానికి ఉదాహరణ చెప్తున్నా. ఇంకొక వెరీ ఇంట్రెస్టింగ్ ఎపిసోడ్ బేస్డ్ ఆన్ లా, జస్ట్ మీకు మామూలుగా ఎపిసోడ్ చెప్దామనే ఉద్దేశంతో చెప్తున్నా. ఇన్ లండన్ The roads were being dug like that happens in Hyderabad. ఎప్పటికీ రోడ్లు తోతూనే ఉంటారు హైదరాబాద్ రోడ్లు. The governance issue ఇది. తోతున్నాడు ఆ రోడ్డు. తోతుంటే one blind man was walking and he fell in the ditch, suffered an injury. Then he filed a suit demanding damages. A blind man walking, falling in the ditch, suffering an injury and asking for damages. How do you answer this question? You will generally ask, why do you go out? Why do you go out? Why do you walk and why do you get into the ditch? That is your general question. But do you know what the question asked by the judge? He summoned the commissioner of London municipality, asked him, do you know how many blind men are roaming around in London city? He says, yes. How do you know? Because I have registered their number. Oh, good. You have registered number of blind people roaming within London. Fine. Then, did you warn the people about your digging of the roads? Yeah, I did warn about. How did you warn? I have put up a board, work under progress, work under digging. Now, how do you think a blind man will read it? How do you think blind man will read it? There are 472 blind men in London city, and you have made a notification which is in English, of course, in writing. But how do you think a blind man will read it? So be liable, he is made liable to pay damages to. So that is again, it is a question of communication. Did you communicate properly? I was looking at these three posters. I was asking my colleague, my friend Madhu, what is this? Those three posters that stood there. What does it communicate? There is a confusion there. Whom are you advertising? There is a confusion there. So in confusion and ambiguity, you don't communicate. When you are not clear in your mind as to what information you have to give, you will simply end up confusing others. And confusing others results in serious damage, economic damage also. It's a governance issue. It's an information issue. It's a communication issue. It's an expression issue. It's an issue of confusion. ఏ ప్రాబ్లం చెప్పండి, ఆన్సర్ చేస్తారు. I welcome confusion. Do you know why? Confusion is starting point of understanding. కన్ఫ్యూజ్ కాలేదనుకోండి, నేను వరి కావాలి అప్పుడు. మీకు అది కూడా అర్థం కాలేదని మాకు భయపడాల్సి వస్తుంది. సో కన్ఫ్యూజన్తో మొదలైతే ఏమిటి నేను చెప్తున్నాడు అనే ఆలోచన మొదలైతే చివరికి అదేమిటో అర్థమవుతుంది. కనుక ఆలోచించడం మొదలుపెట్టండి. సో దిస్ ఈజ్ ది ఇంపార్టెన్స్ ఆఫ్ ది ఇన్ఫర్మేషన్ అండ్ కమ్యూనికేషన్. మనము ఇప్పుడు ఏం మాట్లాడుకుంటున్నామంటే, ఈ మనిషికి సమాచారం పొందే హక్కు ఉందా? డూ యూ హ్యావ్ రైట్ టు ఇన్ఫర్మేషన్? See, normally we have communication necessities, social communications are necessary, needed, and they are being communicated. Kani, do we have right to information? That is the question. Do you have right to information? Generally, it's an administrative, ethical question. అంటే పరిపాలకుడు తను తీసుకునే నిర్ణయానికి కారణాలు చెప్పాలి. Everybody has to communicate reasons for his decision, because you will definitely communicate decision. Why do you hold press conferences? Why do you issue press notes? Why do you organize so many seminars and conferences? You want to give information what you want to give. Definitely you do that. But what I want is not you want me to know, but I want to know what you want to hide. What is that you are hiding? Reasons for decision you are hiding, and I want those reasons for the decision. నిర్ణయాలు నువ్వు చెప్తావు నాకు. Every cabinet, after every cabinet, there is a official briefing of cabinet meeting, is it not? You tell what decisions you have taken, but I ask you why you have taken that decision, or why you have not taken a particular decision. That is my question. There is one provision under Right to Information Act which says, if cabinet has taken a decision, it has to give reasons for that decision, and within that there is an exemption. And what is that exemption? If cabinet has not taken a decision, it need not give any information about that. Now my question is, what do you mean by decision? P.V. Narasimha Rao garu gurtunnaru kada mee andariki. One of the greatest prime ministers who led minority government, not coalition government. There is a difference between coalition government and minority government. Minority government, always it is in minority, but it runs for 5 years. Coalition government, always there are contradictions, but they are together until the term is ended. So these are the two major differences between this minority government and coalition government. So when he was leading a minority government, he faced a very, very bitter criticism that he never decides. Most indecisive prime minister, or who takes no decision at all. After listening to so many criticisms, he answered, "Hey, why do you criticize me that I don't take decisions? I have decided not to decide. Is it not a decision? I have decided to defer the decision. Is it not the decision? I have decided this issue is not supposed to be decided forever. Is it not decision?" Then if cabinet, I'll relate it to right to information. Suppose there are two complexes, multiple complexes are seeking permission, and the permission has to be accorded by the cabinet, because it involves so many economic issues and wider issues than what can be decided by Hyderabad Municipal Corporation. Then cabinet has to decide both the issues. It did not decide on one issue, but preferred to decide on another. That means permission application of Mr. A for building a multiplex is permitted. Application of Mr. B for building a similar multiplex is not permitted. So I get, according to Right to Information Act, I get the information about why A is permitted, but I will not get why B's application is not listed in the agenda. Tell me, is it not corruption? Is it not wrong thing? So that is the deficiency in the restrictions provided in Right to Information Act with reference to cabinet. My answer is again, how do you decide whether it was a decision or not? If it is decision, why not I get the reasons? So reasons for the decision is important to be communicated. There are two terms in law. I'd like to give you general information about it, not because I'm a law professor, because the context demands. You know, there are two terms, decree and judgment. What is the difference between decree and judgment? Decree is the executable portion of the judgment. Judgment is reason for the order. Why I gave this order? He gives a very, very long explanation. 2 pages, 3 pages, 50 pages. In our country we write 1,000 pages. There are 1,000 pages judgments by Supreme Court. So thousands pages of reasoning and one paragraph or 2 paragraphs of orders. Fine. Why reasons? Generally a decree holder goes to execution court. He goes, come on, implement my order. He will take decree there. Do you know what the other man does? He will take judgment to the appellate court for review of reasons. Reasons are meant for review. Every reason can be reviewed. Every reason has to be reviewed. Every reason has to be critically analyzed. Critical analysis, review, revision, appeal are the hallmarks of democratic governance. We are supposed to govern in a democratic manner, in a discussion mode, in a debate mode, in an analytical process. That is what is the information society's demand is. That is what the communication totally aims at. And that is what we are supposed to discuss. And that is the purpose and objective of Right to Information Act. మనం ఎందుకు తెలుసుకోవాలి, ఎందుకు అనే ప్రశ్న మనం నిరంతరం అడుగుతూనే ఉండాలి. తెలుగులో ఒక మాట ఉంది, అడగని వాడి గురించి ఉంది. ఏమిటంటే అడిగిన వాడు అడిగినంత వరకు అజ్ఞానం. వాడు అడుగుతాడు, జవాబు చెప్తాడు, జ్ఞానం వచ్చేస్తుంది. అయ్యా అదేమిటి అని అడుగుతాడు. మా వాడు 7 అంటే ఎంత నాన్న అని అడిగాడు. 7 అంటే ఎంత? కాదు 7 అంటే ఎంత అని అడిగాడు. 7 అంటే 7 అని చెప్పాల్సి వచ్చింది. అడిగినంత వరకు వాడు అజ్ఞాని. అడగని వాడు ఆజన్మాంతం అజ్ఞాని. వాడు అడగడు, ఇంకా వాడు అడగడు, వాడికి తెలియదు. సో వై ఈజ్ ది క్వశ్చన్ that has created abundant source of information in this country. People say that 3 apples have changed the course of world. 3 apples have changed the course of world. First apple Adam and Eve తిన్నాడు. ఎందుకు తినొద్దు అన్నాడు. ఎందుకు తినొద్దు యాపిల్ అన్నాడు. సృష్టి రహస్యం తెలిసింది. రెండో వాడు నెత్తిన యాపిల్ పడితే కోసుకొని తినలేదు. నీ నెత్తిన యాపిల్ ఎందుకు పడిందని ఆలోచించాడు న్యూటన్. ఆలోచిస్తే సైన్స్ పెరిగింది. మూడో వాడు స్టీవ్ జాబ్స్ క్రియేట్ చేశాడు యాపిల్, టెలిఫోన్స్, సెల్ ఫోన్స్, మీకు కంప్యూటర్ సిస్టమ్స్. ఒక కొత్త సృష్టి ఎందుకు అనే ప్రశ్న నుంచి ఉదయించింది. ఎందుకు అని అడిగిన వాడు నిరంతరం అజ్ఞానిగానే ఉంటాడు. ఎందుకు అని అడిగే అధికారాన్ని ఇచ్చేది నాగరిక సమాజం. A civilized society has to give authority to the citizen to question the authority. I must get authority to question the authority through an authority, a statutory authority. And that is what Right to Information Act 2005. Wonderful legislation, fantastic legislation. Do you remember Bofors scandal? Etta telisindi Bofors scandal manaki. How is that we came to know about Bofors scandal? Is it because of great investigative journalism of Hindu and Indian Express? But I give you another source, very interesting source, that is Swedish radio. Swedish radio was telecasting or broadcasting the information about bribing of Indian officials by Swedish companies. వాళ్ళు చెప్తున్నారు అది ఎట్లా చెప్తున్నారు వాళ్ళు Swedish official radio, it is not a sensational media of a private agency, official radio of Swedish. Then do you know what is the reason? Since 1776 there is Right to Information Act available in Sweden. Sweden is the first country to talk about right to information, to give right to information. Free Press Act, it is called Free Press Act of Sweden. A Free Press Act law, right to seek information law. How can a reporter report about the happenings of the society around if he doesn't have right to information? He has right to information, so he will get the information from the public authorities, and that information he communicates. It is a inbuilt duty of a governing agency, public authority, to give information. Information is very, very crucial, not only in governance, even in private life. From Assam, one person was suspected to be suffering from HIV positive 20 years ago. There are no sufficient facilities in Guwahati to diagnose HIV positive. నాకు ఎంత టైం ఉంది? How much of time I have? Oh. So he was taken to Chennai for a diagnostic examination. Along with that patient, a young doctor also travelled, and while collecting the samples, the blood sample of young doctor was also collected by the doctors. When two were examined, it so happened that that patient was free of HIV positive, whereas this doctor is inflicted with. Positive వీడికి వచ్చింది, ఆమెకి ఆయనకి ఏం జబ్బు లేదని తెలిసింది. Then he was shocked and he prescribed some medicines and advised him to be cautious. Then what happened, this fellow who is a young doctor, he has already engaged with another classmate, his own classmate. She called from Guwahati, she called this doctor in Chennai from Guwahati and said, is it true that my fiancée is affected by HIV positive? Is it true? Now what do you expect Chennai doctor to do? Should he give the information? Should he not give the information? And this is exactly called doctor's dilemma. Hippocratical oath says you are not supposed to reveal the information that you come across while performing your professional obligations. But somewhere ఒక అంతరాత్మ చెప్తుంది చెప్పాలి ఇన్ఫర్మేషన్, లేకపోతే అమ్మాయి బ్రతుకు పాడైపోతుంది అని చెప్పాల్సి వచ్చింది. చెప్పినాడు, yes, you are correct, your fiancé is suffering from HIV positive. Do you know what happened? She cancelled the engagement. Do you know what that young doctor has done? He filed a writ petition against this doctor saying that you have violated my right to marriage. Now whether he has right to marriage is the question. Mali, I will be confusing you for some time. Right to marriage unda andarki, manandariki unda. Please remember, all those who are married, they don't have right to marriage again. You can't expect, don't think of all those things. Okay, right to marriage for those who are not married, do they have? Any answer from anybody? Do they have right to marriage? Answer is, it is subject to consent by the other partner. I hope you agree. Unless the other man agrees, where is the right to marriage? Where is the right to marriage? Marriage is a contract. Marriage is a contract, and contract is based on consent.
You are putting the bachelors in crisis here.
No, I am putting them to do some great sincere effort to obtain consent rightfully by giving total information.
No, let them know.
Let them know. So, the question is whether the consent is obtained with free information exchange or not is the question. I am again on the question of information. And if you want her to marry you, you must inform him about your medical status. Medical status is a must information. Today, the parents of the promising brides and bridegrooms are engaging private detectives to know more information about the alliance. Private detectives, and they are well within the legal limits. There's nothing wrong in it. Where is it a private information? A disease about a person, is it a private information? Whether it should be revealed or not, privacy is an exception to right to information. It's another major critical question that is engaging entire judiciary now in the country. But before I go to that question, let me answer this first question which I raised. Right to marriage. Right to marriage is there. It went up to Supreme Court, and Supreme Court said, you are an AIDS patient, you don't have a right to marriage. Because if you marry somebody, you will inflict AIDS and you will be spreading AIDS families. So don't do that. I don't agree. Then human rights activists challenged the decision again. Now understand another possibility of information within this. And do you know what was that information? What was that question? If an AIDS patient wants to marry another AIDS patient, what is your problem? What is your problem? Why do you say that you don't have right to? So then it was amended. Ultimately the judgment was amended. You are most welcome, sir. No problem.
Chandramouli Garu, apart, Commissioner of Apart. Please
You are most welcome. No problem, sir.
occupy your time. Your chair, please. Commissioner Apart, Chandramouli Garu, IAS officer.
First of
Thank you,
all,
sir.
Madabhushi గారికి క్షమాపణ.
Parallel, sir. Information will continue. So it was, the judgment was amended to some extent, and then it was stated that right to marriage depends upon free consent given by the persons. So this is with reference to one single citizen's right to information. Then I'll give you one more example where the culture of secrecy in this country was perfectly challenged by a housewife. One employee of ONGC, one employee of ONGC filed a divorce petition against his wife. Divorce petition was rejected. Then what does it mean? When divorce petition is rejected, you are supposed to live with her whether you like it or not. So that is the situation. This fellow suddenly disappeared. Nobody knows where is he. The only information wife has is this fellow's name is Mr. X and he is working in ONGC. No other information is available to her. How to catch him, how to get him, how to continue the conjugal relationship or whatever it is. Then some information activist came across and he said, why don't you put a right to information question? What is this, sir? Can I get back my husband by putting right to information question? Why don't you try? Then she tried. Do you know what was the question? Where Mr. X is working in your ONGC? When can I meet him? What is his working hours? What is his salary? What is his designation? What are his duties? These were the questions. Then public information officer has rejected it, saying it's a private information. What is private here? I don't know. You can also think of. What is the question asked? Where is he working? What are his working hours? When can I meet him? What are his duties? Where is privacy in it? There is no privacy. Then it went up to public, the appellate authority. Appellate authority agreed with the public information officer, said, no, it's private information, we don't get. Then it went to Central Information Commissioner. Central Information Commission said, you are supposed to reveal this information without somebody asking for it. Section 4(1)(e). You reveal. Yeah, I have so many officers. These are the designations of these officers. They are supposed to work from 9 to 5 or whatever it is. And you can meet them during the lunchtime or after 5 or before 9 o'clock without disturbing the working hours. You should have said all these things. Why did you not say? Then it was inevitable for ONGC to give information to the housewife. Housewife could procure the address and meeting time and meeting with the husband. Don't ask me what happened thereafter. That's a different question, that's a different statute that will deal with. But under right to information, she got the information about the husband. మనం భర్తలు ఎంత గొప్ప భర్తలు అంటే భార్యలకి తమ జీతం ఎంతో కూడా చెప్పరు, ఉద్యోగం ఎక్కడ చేస్తున్నారో చెప్పరు, చెప్పకుండా ట్రాన్స్ఫర్ చేయించుకుని వెళ్ళిపోతుంటారు తగాదాలు వచ్చినప్పుడు. అటువంటి వాళ్ళ కోసం కూడా రైట్ ఇన్ఫర్మేషన్ యాక్ట్ ఉపయోగపడుతుంది అంటే ఎంత ఆశ్చర్యం. So wherever there is an obligation, a statutory obligation, this right to information makes that authority to perform that obligation, to perform that duty, to give information to. Right to Information Act కింద ఉన్న ఒక గొప్ప ధనం ఏంటంటే duty to give information is enforced upon the public authority. That's the most important point. Similarly, a citizen, a voter has right to information about the background of the contesting candidates. Today there is a criticism. You know, they say among 7,000 and odd legislators, they are representing people in the entire country. This figure was has calculated in the recent presidential election. You know, presidential electoral college includes MLCs, MLAs, MPs. So there are more than 7,000 public representatives, and among them 1,441 legislators are charged with serious crimes, and 6 of them with rape charges. Now how do we know that? How do we know that these fellows were charged with criminal cases? Do you know how we came to know about it? Because of that judgment which was given in 2002 by Supreme Court, which says every contesting candidate has to give his criminal history, educational history, economic history. I am not imposing any disqualification. If you are accused in 10 murder cases, no problem, contest. But tell me that you are accused in 10 murder cases. Just give me the information. No problem if you are a bankrupt, but contest, but tell me that you are a bankrupt. No problem if you have failed 10th class 10 times, but tell me that you have failed 10th class. So that is the obligation imposed by a public interest litigation, by Supreme Court in a public interest litigation, initiated by a professor of Indian Institute of Management, Bangalore, Trilochan Shastri, and ఆయన వేసాడు అప్లికేషన్ వేసి దానిపైన మొత్తం ఎంటైర్ పొలిటికల్ పార్టీస్ ఆఫ్ ది కంట్రీ దే అపోజ్. వై షుడ్ వి గివ్ దిస్ ఇన్ఫర్మేషన్? In fact, they made a law, you know, in 2000 they made a law. What that law said? Whatever may be the statement or judgment given by the Supreme Court, no contesting candidate will be under an obligation to give information about his education, economics and criminal history. Then it was again challenged by Trilochan Shastri in Supreme Court, and Supreme Court annulled that law, and it was inevitable for Indian Parliament to come out with a legislation which imposes an obligation to give information to the voters that this is my background, this is my criminal background, this is my economic background. Now we have at least information to know who is contesting. జోకులర్గా చెప్పారు, ఒక ఆయనట నాకు 10 కేసులు ఉన్నాయి, 6 రేప్ కేసులు ఉన్నాయి నా మీద, 3 దోపిడీ కేసులు ఉన్నాయని చెప్పాడు. వాడికి పోటీగా నాకు 3 కేసులే, 3 రేప్ కేసులు, 3 దోపిడీ కేసులు, ఒకటే హత్య కేసు ఉంది. వీళ్ళిద్దరిలో ఎవరికి ఓట్లు వేయాలి? జనాలంతా డిస్కషన్. ఒకడన్నట తక్కువ నేరాలు చేశాడు రా వీడు చేద్దాం, లేదు వీడు వాడితో పోటీ పడి ఎక్కువ నేరాలు చేస్తాడు కనుక వాడికే వేయడం. So whatever it is, there is a scope. I'll explain you the joke. There is a debate. Whom to vote? A person who is charged with 10 offences of murder, 6 offences of rape and 2 offences of dacoity, or a person who is charged with 3 offences of rape and 1 offence of dacoity or less number of offences. Somebody said, let us vote this fellow who is having less number of crimes to his record. That's what they thought. But some other fellow said, no, he will be competing with the other man. To settle the score, he will commit more crimes. So don't elect him only. So that is a jocular expression. But what I mean to say is, any information that flows to the people will form basis for the discussion, and discussion leads to decision, and decision making process is more important in democracy, and I must be having enough information to decide whether to vote this fellow or that fellow. Similarly, government has to have enough information to decide this way or that way, and they have to give reason for the decision so that I decide whether your decision is correct or not. So this is the crux of the right to information. I am not going into the provisions of Information Act. I want to give you the importance of right to information. For the first time, Right to Information Act gave a legal right to the citizen to seek information and imposed a duty on the public authority to give information. Oka chinna incident cheppesi nenu mugistanu. I know that I have taken a lot of time. In Mahabharat, what happened? The Kauravas heading huge quantum of army was defeated by Pandavas, who were having less number of soldiers. The reason is only one, that is Lord Krishna. What is the significance of Lord Sri Krishna? Lord Sri Krishna is endowed with information and knowledge. He was advising the Pandavas, do this, do that, don't do that, don't do this. And that was the purpose, that was the reason, that was the efficiency, that was the enabling information that made Pandavas to win, even with less strength. So information is wisdom, wisdom is victory. And you will win all kinds of wars if you know that you are waging a war, and you will lose all wars if you don't know that you are entered the scene of the war. Half of the battle is won if you know that battle is at forefront of your gates. If you don't know it, you will lose it. If you know it, you can strategize and you can win the war. So my suggestion to all of you is, please understand, information is enabling, information is empowering, and information is incapacitating. And an enabling information, incapacitating information, empowering information has to flow from one end to the other, and this transmission of information can happen by effective communication, and all public relations officers are endowed with the capacity of communication. I'd like to give you the difference between PIO and PRO. Public relations officer gives information what his company or his authority wants. Public information officer has to give information what people want. This is the major difference, understand it, and be very communicative, be informative, and be educative. Thank you very much for this opportunity.